Are insurance companies playing by the rules here in the California workers' comp system? Are they actually looking for your best interest? Or are they playing games, playing dumb, and there's things you can do about it? Hi, my name is Carmen. I am your host from Work Comp Talk Podcast. Joining me as usual, managing attorney from Pacific Workers, Bilal Kassem. If you haven't checked out Pacific Workers, they are also our sponsors for today's podcast. Make sure you do so on pacificworkers.com. There's a lot we're going to unveil today, and in particular, penalties, sanctions that people don't even know they have a right to when it comes to dealing with their workers' comp case. Where do we start?
Well, I think it's important to understand, what penalties and sanctions are and, what is the procedure for actually getting them. And then we could talk about the types and, what kind of available remedies are and when they are available to people.
Let's do it. What are penalties and sanctions?
So penalties and sanctions are a way that the court would punish an insurance company, potentially even an applicant, depending on the situation.
Wow.
And the idea is that the court wants to make sure that the insurance company and everyone else is really holding up their end of the bargain and doing what they need to do.
Which, unfortunately, we've learned with so many cases that you've dealt with in the firm, that's not usually the case.
Yeah, for the most part. And, earlier I had mentioned that, applicants can even be sanctioned, but that's really when they just have an attorney and the attorney that they've hired isn't really doing their thing. Sanctions are really designed to punish the insurance company more so than anyone else.
So give me a scenario where someone would be able to, see a red flag and call this out and potentially do something about it.
One of the most common ones, I would say, is when an injured worker is not receiving their payments on time. Or
what type of payments? Would this be like the settlement, or would this be the disability benefits?
Could be both.
Wow.
So throughout the life of a case, injured workers are entitled to things like temporary disability as well as permanent disability. And I think oftentimes checks go missing, or the insurance company doesn't pay because they disagree with a medical report, or they're just asleep at the wheel and they don't know or haven't paid attention to the case, so they haven't paid the benefits. And when the insurance company hasn't paid benefits, they're on the hook for late penalties, which can be up to 25%, 10% if it's self-imposed, and potentially also sanctions for bad faith, frivolous conduct.
What does this mean for the injured worker?
I think for the injured worker, it means you have something in your war chest to use. You're not just at the mercy of the insurance company, and there is a way to hold them accountable for the wrongdoings they, throughout the life of your case, I guess. The one issue is that, are the penalties and sanctions really proportionate to the damage they're doing? Let's say you have a $1,000 check you're owed, which is, a lot of money. But let's say that $1,000 check is late. They owe you $250 in penalties. Does that $250 in penalties really move the needle in punishing a multi-billion-dollar insurance company?
Nothing.
I don't know how effective it is. In civil court, you have things like punitive damages, which are entirely designed to punish. You often see cases where someone's punitive damages are like, 9 times, what the actual damages are, and it's because it's a big company and they deserve a bigger slap than they would otherwise.
Right.
But in workers' comp, it's rather limited.
Now, this is what my brain is giving me and feeding back with some of the stuff you're mentioning right now. Say those $1,000 were going to go towards your mortgage because you were at the point where you're about to lose your house. Unfortunately, you don't get that money on time because the company or the insurance company decided not to send it to you. You end up losing your house, yet you get $250 just because oops, sorry, we made your payment late and you lost your house. Obviously, this could be the case, or the last, payment you need to make on a car. It doesn't necessarily have to be a house, but is the $250 worth it? So let me just slap them in the hand. It sucks. It really does suck. And the most sad part I can think about this from all of this that you just discussed is people probably don't even know they have this right. If my check comes late, I don't even know I'm going to get a penalty and sanction extra fee. It's like, if you don't ask for it, will they give it to you?
No, and, even then it takes a lot. Most often the insurance company doesn't just say, oh, we messed up, here's extra money. That's,
No.
Oftentimes it requires filing a motion with the court, bringing the case to court, putting the case before a judge, and sometimes even having to try the issue.
It's interesting.
And so they don't just hand out penalties and sanctions like it's candy. You know, they really make you work for it. And in particular, on the insurance side, adjusters never want to have penalties and sanctions on their file. It's kind of like a black mark against them as an adjuster.
Okay.
And also, if a judge awards penalties and sanctions, technically they can report the insurance company to the audit unit. And if, you know, there's an audit of that particular insurance company, I believe the penalties can range up to $400,000.
Wow.
If there's an audit and it's determined that the insurance company is, you know, chronically messing things up and not doing what they're supposed to do legally.
Right. Now, you've mentioned having certain due dates that, you know, time limitations, that if they don't pay after a certain amount of time. Is there a place where someone can go and know and find out what these time limitations are? Like, how long does an insurance have to give you a settlement check?
Sure. Some of it, you know, there's Labor Code 4650, which basically says when payment of disability benefits are supposed to start and stop. You know, Labor Code Section 5814 talks about, you know, unreasonable delay in benefits. 5813 talks about bad faith, frivolous conduct that's sanctionable. There's 5814.5 that says, you know, there's hourly attorney fees, basically, if we have to go enforce an award for late payment. Mm-hmm. And then when you're looking at settlement documents themselves, so, you know, it's typically written in there that, you know, there's no penalties or sanctions if payments made within 30 days from the date of the award. So the insurance company does have time limitations built in, and I would say more often than not, it's usually late checks and the late settlement payment that we see the most.
Yikes. Like, when you say the most, is it a good chunk, or is it just once in a blue moon?
You know, I would say late temporary disability checks or late permanent disability checks are probably the most common. Mm-hmm. Every once in a while, there's a late settlement payment. And, you know, when you're talking about a late settlement payment, you're talking about a more significant amount of money. You know, if someone's owed $100,000 settlement, 25% of that, $25,000, that's a pretty hefty penalty.
Mm-hmm. Interesting. If someone is not represented by an attorney in any way, shape, or form, is this something that they can potentially appeal? Is this something they can move forward with on their own? Is this, you know, easy?
You could try. I mean, you have to try the issue potentially. Depending on the insurance adjuster, you know, if you understand the law and what your benefits are and what rights you have, you could make an argument to them and maybe they'll believe you and, you know, say, hey, you know what, we'll pay you. And oftentimes we do negotiate penalties without having to go to court. But usually it's some discount on what the penalty is to just actually pay it. You know, like let's say there's a disagreement about temporary disability. We think they should have paid, you know, there's a penalty. Maybe it's not that big, you know, maybe it's like $100 or couple $100 or something like that, and the insurance adjuster says, oh, you know what, I'll pay the whole amount, plus I'll pay, you know, a 10% penalty instead of a 25% penalty, and they're willing to do it right then and there and get the check out to our client who's in need, versus saying, no, we want the full 25% and we're going to wait till we go to court in, you know, whatever, 60 days, 90 days, go to trial, wait. You know, sometimes getting the client a penalty, not the max penalty, and ensuring that they're getting their benefits is more important than getting the total amount, you know?
Right.
So we always have to act in the best interest of the client. Usually that means getting them something sooner than waiting it out. Unless, of course, the client has the luxury to wait it out. And we're like, hell yeah.
I'm so glad you brought that up, because my next question was actually going to lean towards that. Let's just say you're good, right? Let's just say, you know, your wife or your husband is picking up the bills, and you can have the luxury of waiting it out and play stupid and pretend like you don't know you have these rights as penalties and sanctions. And then the insurance doesn't bring it up, so you don't bring it up. And you kind of just let this piggy bank rack. Does it even rack up? Or does it cut off at a certain point?
No, I mean, it depends on what it is.
Okay.
So, like, if you have, let's say you're owed temporary disability, and as an attorney, I've made a demand to the insurance company to pay temporary disability, and they haven't paid, and no one said anything. And, you know, weeks go by, months go by, the more temporary disability keeps accruing, so does the penalty attached to that.
Wow.
So I guess theoretically you could, but I think more often than not that doesn't happen.
Yeah.
But on other things, it doesn't continue to accrue.
Okay.
You know, like, for example, if there's an unreasonable delay in treatment authorization, we used to go and try and get penalties on the value of the treatment, things like that. And those, of course, would be kind of more fixed than anything else. But yeah, usually when you're talking about benefits being accrued, yeah, you know, the penalty would accrue on continually late.
Interesting.
Payments.
You mentioned treatment, like delays. That's scary. That's something that a lot of people probably face. But let's just say you really need this surgery done ASAP. They keep delaying it. Your surgery eventually ends up happening, but it's too late to kind of remedy some of the things that could have been fixed had they've done it earlier. What happens in those situations?
Well,
Does the settlement go higher?
It could. You know, that would be a penalties and sanctions issue. So, you know, there'd be attorney's fees involved, penalties. You know, sanctions aren't necessarily attached to anything. Penalties, the term specifically is usually attached to something.
Okay,
you know,
gotcha.
a percentage of a benefit or a percentage of something that's owed to them. Whereas sanctions aren't necessarily expressed as a percentage. It's just a monetary amount designed to punish the insurance company. So, you know, you could ask for sanctions in X number of dollars for whatever's going on. You know, it just depends. But I think more often than not, when you're talking about delayed treatment, you're talking about treatment that's been, you know, denied by utilization review, and, you know, maybe it's overturned by IMR eventually, but that wouldn't be a penalty situation. You'd be in a penalty situation if, for example, the doctor submitted a request for authorization to the insurance company and then they didn't do anything with it. And, you know, months go by of you saying, hey, you know, where's the utilization review decision? Are you guys authorizing this or denying it? You know, where's the IMR application? Why has nothing been done? And you just keep getting the cold shoulder from the insurance company. That would be a penalties and sanctions issue.
And you take them to court. Do you request for a quick hearing? How does that roll out? How does that go about?
So there's different types of court hearings. The first regarding treatment and benefits is what's known as an expedited hearing, meaning that you can get on the calendar more quickly than you would otherwise because the court deems benefits and medical treatment kind of more key important issues. So they try to make sure those things get fast tracked. Even then you're talking about 30 days or something like that, versus a mandatory settlement conference, which is for pretty much any other issue you want to try. Those take longer. Expedited hearings themselves are kind of mini trials, versus mandatory settlement conference are considered pretrial hearings where you set the case for trial on whatever issue you want to after that. And so the key is that permanent disability, temporary disability, if they're late payments, things like that, you can address those at an expedited hearing. Same thing with medical treatment. You can't address penalties and sanctions at expedited hearings. So, you know, if you want to address a penalties and sanctions issue, you need to request a mandatory settlement conference, which can extend out the time it takes to get the ball rolling. So kind of puts you in a tough spot when you're at an expedited hearing to address, you know, treatment or benefits, but you're also wanting to address penalties and sanctions.
It's interesting because if someone's not being represented legally by an attorney and having to deal with all this back and forth, having to deal with all this extra amount of work, paperwork that you need to turn in, and just all these hearings, like, just think about it. You're trying to recoup. You're not 100% healthy. There's issues going on with pain, probably. And on top of that, you have to deal with all this BS. Like, this is why you hire the attorneys, have them handle everything so you can just focus on trying to feel better, trying to get better, and have someone that already knows it's the system just fight for you. Like, I don't think I would have the nerve to just be like, you know what, I'm gonna sit there and file for an expedited hearing. I'm gonna make sure I get all my shit together. Like, that's not gonna happen, especially when you're in pain.
Yeah, and I think part of it's, you know, we try to balance everything we do too. You know, when we try to make sure that, you know, if we're going to take a particular course of action, it's worth the time and effort to do it, and also it's meaningful for the client. And we also try to get things resolved. You know, I think we try to give the insurance company an opportunity to remedy things where we're required to. So when you actually file for a court hearing, you're supposed to certify under penalty of perjury that you've informally tried to resolve the issue before, you know, requesting the court's attention. You can't just like file for hearings whenever you want, left and right. And then even once you get a date, assuming that you can't work it out informally and you've wasted that time, you still have to wait for the court to hear your case, which, it could be a month, it could be 60 days, depending on what the issue is. And all the while, the injured worker, the client's still sitting there, and they're not getting their benefits or they're not getting their treatment. So clients have always explained it's frustrating for their perspective. And, I get it. It's just we're also operating within a very limited system with limited scope of rules and limited tools that we can use to move things forward.
And this takes it back to my opening statement. Do insurance companies really have your back when it comes to the California workers' compensation system? For the most part, they should. They want to. But there are situations that they get themselves into that prove otherwise.
Yeah, and we see penalties and sanctions issues quite frequently. It's not like it's a once in a while thing. It's often.
You got to tell me, what has been one of the craziest situations for penalties and sanctions that you can think about? Like, they screwed up and it's like, I can't believe they did that.
So there was one time our client was supposed to have a surgery, and it was arthroscopic shoulder surgery, I believe, if I'm not mistaken. It was a few years back. And the doctor had submitted the request for authorization through utilization review. And, of course, nothing happens, right? For, weeks, we're like, hey, what's the decision? Is this done? Defense attorney at the time was like, yeah, I thought I saw the utilization review decision denying it. I'll make sure I get it to you, blah, blah, blah. And we're like, okay, that's fine. We'll submit this through IMR, the IMR appeals process. If it's there, just get it to us so we can start this process. And we also want to review this to make sure it's correct. Literally weeks and weeks and weeks go by, nothing. So, of course, I filed a petition for penalties and sanctions. I also filed a petition to ask the court to force the insurance company to authorize the treatment because they didn't actually provide a valid utilization review decision to me. And so we get to an MSC, because that's the type of hearing to address all this stuff all at once rather than piecemeal. And the defense attorney's like, I still don't have anything. It is what it is, So the judge obviously is not happy with that. And so, okay, well, clearly, if they didn't put this through utilization review, they don't have anything to show for it. I want penalties. I want sanctions. I want this to be authorized, all this stuff. And so finally, it's now months later, we're at the trial date. And we're like, okay, we're ready to go to trial, literally the day of. And the defense attorney walks into trial and says, oh, well, my client has agreed to authorize the surgery. So, authorization for surgery is a non-issue. Well, the board doesn't like to try penalties and sanctions issues by themselves. So, for example, if that's the only issue, the court will say, you know what, I'm going to defer this.
Oh.
And so, literally the morning of trial in court, the judge says, well, if surgery is authorized, the only pending issues are penalties and sanctions. I'm going to defer these. And so we didn't get to try the issue of penalties and sanctions.
They pushed your button to the last second possible.
Yep. And obviously it's by design. The defense attorney knows, hey, you know what? If we just authorize the surgery, then, there's no penalties and sanctions issues to be tried. It'll just get deferred. And ultimately, those typically get resolved at the time of settlement.
That's insane.
So, that was a frustrating process for my clients.
I bet.
Shit, I waited, months. I'm getting my surgery. Yeah, but when are they going to pay for the delay? And so
stupid.
The common tactic at the end of the day is to rope the penalties and sanctions that have been deferred or not addressed throughout the case into the settlement, because
of course
it's their kind of way of brushing it under the rug and being like, oh, you know what, we'll give that person $5,000 more or whatever, and we won't call it penalties and sanctions, but it'll just be more money to them and the case is done, rather than having the judge actually award penalties or sanctions, or the adjuster having to write a separate check for that amount.
That's insane.
Yeah.
That is crazy.
So that's a frustrating experience.
Definitely. In the beginning of this podcast, you also mentioned that, roles can reverse and the injured worker can also be penalized. Give me some examples and let's talk about that.
So you could have a really bad attorney representing you, and
I know a few.
The defense can ask for penalties and sanctions too. There's things that applicants' attorneys have done in the past that I know of that are, not above board. It's considered unethical, potentially illegal, criminal, and obviously those things can get the applicant's attorney into trouble too.
What things?
Well, if an applicant's attorney lies to the court.
Gotcha.
So, an example of this would be if we're fighting over whether, I don't want to be too technical because I want it to make sense, but the applicant's attorney, said they mailed something out, they sign a proof of service that it was sent out, right? And maybe they said they sent something out and they falsified the proof of service to the court or something like that. I've seen that happen before, which is really messed up. But for like the applicant themselves, an applicant can be penalized if they don't participate in their case. So there are certain code sections that allow for the insurance company to suspend payment of benefits and even potentially bar the applicant from collecting benefits if they don't do what they need to do.
Right.
And so one of those would be, for example, if the insurance company wants to take their deposition and, the applicant doesn't show up, then the attorney for the defendant would file a motion to compel the applicant to appear. And if the judge grants that, that means the court's ordering the applicant to appear at their deposition. And so if the applicant doesn't appear at the deposition, then the defense attorney can actually ask the court to suspend the applicant's right to collect benefits until they do appear at a deposition.
Interesting.
And then potentially, even bar their right to collect benefits. So that would apply, for example, to a QME evaluation as well.
Right.
So there's scenarios where the applicant can be penalized. If the applicant commits work comp fraud, that wouldn't necessarily be something they're penalized for per se at the work comp appeals board level. They could be forced. There could be a position where, for example, their temporary disability is credited against all future benefits because maybe they were working at the time and lied about it. But they would expose themselves also to fraud prosecution.
That's a fraud. That's a whole different.
Yeah, so they'd be potentially
that's a felony. That's
criminally
a
charged by the district attorney for work comp fraud.
And you still have lots of fees you're going to have to pay for those charges.
Yeah, you can be ordered to pay restitution, which essentially means that you have to pay back all the benefits you received, as well as potential prison time, as well as fines. So
Dang.
there are those situations are rare though. It's not often you see an applicant get penalized like that. It's just most people they're injured and they just want what they're entitled to, and that's it.
That's good to know. It doesn't happen often on the injured worker side. Is there anything else we need to dive into in regards to penalties and sanctions that we have not discussed?
I think you always want to make a strong case for it. If you are going to get penalties and sanctions, make sure you have everything lined up. Make sure you're diligent in documenting your efforts. For example, if you feel like your benefits were unreasonably delayed, make sure you have letters and emails supporting your communication with the adjuster or the defense attorney, expressing that your payment's late and why. That way it's ammunition when you go to court. If you need trial exhibits, for example, you can show the judge to justify it.
And I know it's hard because sometimes they'll try to jump on a call and literally just want to speak to you.
Yep.
But that's when you write back to them and, hey, per our conversation, I just wanted to confirm that this is X, Y, and Z. They may not reply, but you have it in writing that you had a conversation with them, and that's what you spoke about.
Yeah. And then I guess for treatment, my one word of advice would be make sure you get a copy of the request for authorization that was faxed to the adjuster. So you have fax confirmation that was provided to them. So if they don't issue a timely utilization review decision, you can say, look, here's proof that it was sent to you, and now you need to authorize my treatment. So those are good tips, but yeah.
Nice. This has been very, very revealing into some of the things that people may not otherwise know unless you know the law. And it's one of the topics that we've discussed constantly here in the podcast. You don't know what you don't know. If you're just an average person saying, hey, I'm going to take my own case, and you come across one of these, I am so out of words today. Roadblocks where you're not getting your temporary disability benefits or paid on time. You kind of just like, oh, well, they said they mailed it, or I'm going to wait for it. And then you eventually get it, a month down the road. You kind of just let things fly because you don't understand that there are rights for this. Even settlements. I feel like it's rare for settlements because, like you said, it's a higher amount that they have to pay if they were to get penalized for not paying a settlement on time. But let's just say they were a day late and you're just like, oh, at least I got it. It's like.
And you know what? I would say for the most people, or for the most part, people are reasonable.
Yeah.
And, it's the attorneys are the same way. The clients are the same way.
Yeah.
I'll tell clients like, hey, they issued your check one day late. Do you want me to do anything about it? And they're like, no, it's fine. They paid it. It is what it is. You know what? It's not worth, we don't need to go do it and stuff.
Yeah.
And same thing, You know, if I know particularly, you know, an adjuster that's been doing it for an extremely long time, and normally they're always on top of it, like they never miss treatment authorization, they never miss benefits, you know, they're always a great adjuster, and they're, you know, a couple days late on one payment. Do we, you know, jam them up? You know, most likely not. We know it was an honest mistake.
Right.
The client doesn't really care. It's not a big deal. You know, everyone's cool. I think we really go after things when we're just being ignored. You know, when it's like, I've emailed the adjuster 5 times, I've called them, they say they're going to do something, they didn't, you know, and they've, you know, they're lied or they just don't care enough. And that's when we really hold their feet to the fire.
It's crazy. Well, it's good to know. Yeah. Well, that wraps up this episode. We hope you really got a lot of information useful that you can essentially learn if you're fighting a workers' compensation case here in California. Like always, if you have any questions, make sure you dump them in the comments section, or you can always reach out to us on social media. Make sure you guys hit that subscribe button so you guys get notified when we upload new content, and we'll catch you guys on the next episode. Thank you.